this. This presentation is on collection due process, and let's see. Okay, just a little about me. And as way of background information, if you owe the IRS but don't pay your tax liability in full, the IRS, of course, will send you a tax bill demanding full payment. If you don't make payment in full or make other payment arrangements, the IRS will pursue collection of the taxes through liens, levies, or garnishments. And that's really what we're going to be discussing in today's webinar, these liens, levies, and garnishments. So just a basic overview on liens and garnishments. And as most of you know, I like to give a general overview and then delve deeper into the weeds, so to speak. So this is tax liens. A tax lien essentially establishes the government's right to seize your assets and use the proceeds to pay your tax liability. As we all know, the filing of a lien is very burdensome. It affects credit ratings. It wreaks havoc in the lives of our clients. Third parties dealing with your property may find their position subordinated to the position of the IRS. And the IRS is basically considered in bankruptcy law as a super creditor. And there's a lot of myths out there that if you go through a Chapter 7 bankruptcy, that it absolves all liens, including that of the IRS, but that is purely a myth. While bankruptcy can, in fact, erase the liens and debts of other creditors, the IRS is the exception. And there's a lot of nuances involved in that, and the bankruptcy lawyers are always good to consult just to make sure that the lien is not, the lien would remain in place and would not be removed in the event of a discharge. Moreover, the filing of the lien will be reported to credit agencies and, of course, will and can adversely affect the client's credit. So if the IRS places a lien on your property, there's some things that they have to do. And this is the body of law that we have come to know as collection due process. They have to send the client a notice of the lien. And there's a time frame here. The notice of the lien has to be sent within 5 days of the lien being filed. And you will see here that there are a lot of hard and fast deadlines that are discussed. And the significance of these hard and fast deadlines is that if they are not satisfied by the IRS, they give you the ammunition that you need to fight back and to have the lien quashed. So be very conscious of these deadlines. If you want to appeal the placement of a lien on property, you have to request a collection due process hearing with the Office of Appeals within 30 days after the 5th day the lien was filed. So you'll see here that it works both ways. It works on the IRS, where they have to send that notice within 5 days of the lien being filed, and then it works it makes a response. It then shifts the burden, I should say, to the taxpayer, such that if they want to request a collection due process hearing with Office of Appeals, they have to do so within 30 days after the 5th day the lien was filed. So this is why you get a vision in your mind of Sherlock Holmes with a magnifying glass scrupulously looking at the notice to determine when things were filed and all the dates and what have you. If you fail to request the CDP hearing within the 30-day period, you'll forfeit your right to the hearing. However, you may obtain an equivalent hearing. Now, a lot of people ask, well, what's wrong with that if I get an equivalent hearing? Well, here's the problem with that. If you, or rather your client, is not successful at the equivalent hearing, there's no right to appeal that adverse ruling. Instead, it'll be lost. Whereas if you properly make a request for a collection due process hearing within the 30-day period, you get the right to appeal an adverse ruling, and that's what the distinguishing factor is. Avoiding liens. The Internal Revenue Code and the IRS's own procedures give properly informed taxpayers the opportunity to prevent the filing of tax lien notices, but you have to be proactive and work with the IRS. I think this is just very, common and basic knowledge. A lot of times people who have liens, who've had liens filed against them, have dug their head in the sand like an ostrich and ignored the notices that they were receiving from the IRS. And typically, the IRS, this is something that the IRS saves as a last resort. They don't go to this right away, filing liens. This is something that has happened at the end of the process where they've been unable to get the taxpayer's attention through other means. So the taxpayer partially is at fault, and there's a variety of reasons. Most of the time it's fear. Other times it's that they don't have the money. Other times there's tax protester arguments that they raise. But at the end of the day, this is the last resort, and it's it's difficult at this stage to do anything except damage control. So the idea here is to be proactive, and of course it's up to the client to seek counsel and seek advice at the earliest stage possible when they're notified about this. And sadly, that's not always the case. Failure to do so results in the filing of these nettlesome notices in the public record, and it's very difficult to get the lien removed. After a lien has been filed, it's important to have the lien released. Well, I made that sound as if it's very matter of fact. That's what the whole objective and the whole process is designed for, to get the lien released as quickly as possible so it doesn't have as damaging an effect on the credit rating of the taxpayer as it potentially can and will. Or to have certain assets removed from attachment of the lien so that the property can be sold or refinanced, or so the taxpayer can obtain a new loan to resolve its tax problems. And this is where it's almost like a catch-22, where the taxpayer, now has property that's been attached to, and they come to your office and they say, I just want to get this behind me. I should have taken care of this bill, or, for whatever reason, I, just blatantly disregarded it, and now I want to sell these assets and I want to just pay the liability. Well, if the IRS is already attached to the property, that becomes an issue because it's going to be difficult to even get a lender to extend credit on property that's been attached to. So in many cases, there aren't options except for selling the property outright, and that's not always an option that the taxpayer wants. It's usually one that can cause a lot of issues, collateral issues in their lives. So in these cases, the IRS can issue several kinds of certificates with respect to previously filed liens if it comes to getting the liens released. Now, a levy, by contrast, is the IRS's way of getting your attention. It's the actual seizure of wages or commissions or whatever other assets the IRS can find to pay off your debt. This can include bank accounts, IRAs, automobiles, stocks, bonds, and as a general rule, anything that isn't nailed down, and some things that are. For tax levies, you have 30 days from the date of a final notice of intent to levy to pay the tax in full or find another answer. Ignoring the notice, as with any other IRS notice, usually makes matters worse, because once those 30 days has passed, the IRS does not have to give any further notice before automatically resorting to the nuclear option of seizing the assets or wages. Now, before the IRS can levy on the taxpayer's property, we've already discussed this before, they have to provide the taxpayer with an opportunity for administrative review of their collection actions. And after the appeals officer renders its decision in the form of a notice of determination, the taxpayer has the right to appeal an adverse determination to the tax court. So before getting too excited, it's a very sterile review, this opportunity for administrative review. And you will see in subsequent slides, the administrative review consists of ensuring that the IRS's collection actions were in full compliance with the time frames that we've previously discussed. And to the extent that they were, that's pretty much enough for a rubber stamp by the Appeals Division. And sadly, most of these decisions go against the taxpayer and result in a notice of determination. And that's why it's always nice to file the protest within the within the required time period, because in many of these cases, as I said, the taxpayer loses and wants to appeal. If the taxpayer waits too long to file the protest and is left with an equivalent hearing, there's no appeal rights. So taxpayers are entitled to CDP hearings in two situations: after a notice of lien is filed and after compliance issues a notice of intent to levy. Notice of the tax lien. The IRS may file a tax lien. The filing of this lien, of course, is very burdensome. Third parties dealing with the taxpayer's property will find their positions subordinated. That just means placed behind the position of the IRS, so that the IRS essentially becomes the head creditor at the very top. Moreover, the filing of the lien will be reported by credit agencies, so this is just a little redundant. Again, the IRS must notify the taxpayer in writing of the filing no later than 5 days after filing the lien. The notice must state in simple terms the amount of the tax and the taxpayer's appeals rights. The taxpayer invokes his right to a due process hearing by filing the request within 30 days after the expiration of the IRS's notice period after the filing. And I know that that's a mouthful, but that essentially is 5 days after the filing of the lien. So the process consists of the IRS filing the tax lien, and the 30-day period does not commence until the 5th day after the IRS physically filed the tax lien. What happens if the taxpayer fails to request a hearing within that 30-day period? Once again, he forfeits the right to a CDP hearing, but may obtain an equivalent hearing in which there is no appellate review. What happens at the conclusion of the hearing? Well, the IRS may either file an appropriate document to reverse the filing of the lien, or it may issue a notice of determination. Now, the notice of determination, if it sounds a little bit like the notice of deficiency, it's not the same thing. There are differences. However, it serves the same purpose as a notice of deficiency in the sense that it's a taxpayer's ticket to an appropriate court for judicial review. So just like a notice of deficiency is the taxpayer's ticket from appeals to U.S. tax court, the notice of determination serves the purpose as being the taxpayer's ticket to an appropriate court for judicial review as well. The taxpayer has the right to request judicial review of the appeals determination. Subject to a few exceptions, the IRS must give the taxpayer notice of intent to levy before the levy action is taken. So now you see we are transitioning to the levy. The IRS notifies the taxpayer of his right to a due process hearing on the levy action and other taxpayer rights with respect to levies. Exceptions, there are some exceptions to the issuance of the notice before the levy action is taken, and those that are most common are ones that deal with state income tax refunds and situations where collection of the tax is determined to be in jeopardy. So to the extent that the taxpayer expects or anticipates a state income tax refund, and yet there is a levy act, and yet there is a potential for collection action, the IRS may actually levy on that state income tax refund before issuing a notice of levy. And the Internal Revenue Code does permit them to do so. The other example being the second one, where the collection action is in jeopardy, where the IRS fears that the taxpayer is a little slippery and might do something nefarious to shield or to protect assets. And in those cases, there is no requirement for notice. The taxpayer must request a hearing with respect to the notice of intent to levy within 30 days after the required notice is given or sent. If the taxpayer doesn't do so, he forfeits the CDP hearing, but as in the case of the notice of intent for lien, he is entitled administratively to an equivalent hearing, but there's no judicial review. At the conclusion of the hearing, the appeals officer issues this notice of determination, and if the taxpayer remains unsatisfied, it is his or her ticket to judicial review. The taxpayer has the right to request judicial review of the appeals determination. Now, how does a taxpayer request a CDP hearing for appeals consideration of the disputed collection action? Well, this is a mere bare bones list of the things that must be included in a request for a CDP hearing. All the basics that would necessarily be included in a protest to appeals: the name of the taxpayer's address, a telephone number. I always cringe when when there is a line on a standard IRS form that requests the taxpayer's contact information, because if I am representing the taxpayer as his or her attorney, or if there's a tax professional representing the taxpayer as his or her tax professional, we are the representative, and I don't want my client being contacted directly by the IRS. Because time and time again, even when you warn them not to talk to the IRS and not to correspond, the impulse is this knee-jerk response to get on the phone thinking that they'll be able to clear everything up or to write a letter. So, as I said, I always cringe, but some of these form letters that the IRS do require a contact telephone number for the client. Signature and date. On the protest, the taxpayer should indicate the alternative collection action that he or she wants the IRS to take instead of levying on his property. So as you can see, this protest has some, or bears some resemblance to these other modes of collection, alternatives, such as an installment agreement or potential other ways of settling the debt with the IRS. So you can be as creative as possible. Of course, what you want to do all the time is consult with the taxpayer to find out what they can do and get from them an idea of, perhaps how much, they might have liquid at the moment to put down in a lump sum, and whether, the potential for a monthly installment agreement would work, and if so, how much they can realistically afford to pay. We as tax attorneys and tax professionals go through this all the time, and again, this is restating the obvious. You always want to consult with the client to see what they can do, and if they, if they say, oh, I can, do X number of dollars a month after putting Y down as a initial down payment, you always want to make sure that this is a realistic figure and that they're not just they're not just reacting impulsively, because if they don't stick with the figures that they make, as an offer in this protest, then there are consequences. And that's not to say that if they pick a lower number that they can't pay more every month. That's certainly a possibility. So I oftentimes err on the side of caution, and if a client says, they can afford X a month, I usually subtract that or tell them to be a little bit more prudent and realistic, and perhaps adjust that just in case there are some unforeseeable circumstances, because we obviously can't predict that what's going to happen, and we need to make sure that there is a safety cushion just in case. During appeals consideration, what happens with the collection action? Well, that's the $50,000 question. With liens, there is a difference, as you can see here, between liens and levies. Since the notice of federal tax lien has already been filed, and the rationale is that the taxpayer is notified once the notice is filed, even if they haven't been notified, there's this theory under the law of constructive notice. So once the lien has been filed, the taxpayer is deemed to have to be under, at the very least, constructive notice of the lien. And so the idea here is that the taxpayer has notice of the applicable CDP rights, and requesting a hearing has no immediate effect on the collection action. So that can sound a little crass and unseemly, especially if the taxpayer doesn't have actual notice. But again, going back to some property law concepts, this is all steeped in property law. The theory of constructive notice, that once this lien is filed, the taxpayer is deemed to have, at the very least, constructive notice, even if they are completely oblivious to it. And as a result, requesting a hearing does not toll the collection action. It has no immediate effect on it. For levies, levy action is actually suspended during the period of time that appeals is considering the taxpayer's request for a CDP hearing relating to the notice of intent to levy. In equivalent hearing cases, collection action can move forward on the levy if the IRS determines that collection of tax is in jeopardy. You'll find that this phrase, collection of tax in jeopardy, is the exception that really swallows up the rule. That's not to say, however, that the standard can easily be met. It's still a heightened standard, and the IRS can't just arbitrarily say that the collection of tax is in jeopardy, because of the color of your client's hair or because of an area of the country where your client lives. There has to be a very specific reason why the IRS is relying on this exception. What effect does a CDP hearing have on the statute of limitations and collection actions? Well, this is a major drawback for taxpayers involved with the CDP process, and that's because the statute of limitations on collection is suspended. And for those of you, just to back up a little bit, the statute of limitations is basically the clock that is ticking on the IRS. And it's ticking on the IRS because the IRS has a limited period of time in which to carry out its collection action. That period of time varies. As we all know, there's traditionally, when it comes to statute of limitations on making assessments, it's usually 3 years, but as we all know, there are so many exceptions that can broaden that period from 3 to 6 years. Well, it's not much different in the world of collection due process. There are exceptions that can all but swallow up the rule. But the statute of limitations is basically the friend of the taxpayer, in the sense that the clock is constantly ticking and ticking and ticking and ticking against the IRS. But what the drawback is here is during the CDP process, the clock stops ticking. And that inures to the benefit of the IRS because the IRS no longer has the proverbial gun to its head on collection action because the collection is suspended beginning on the date that the IRS receives the hearing request. Very important that you make your client aware of this. I can't tell you how many clients have, once we filed the hearing request, have, come back to me and said, well, the IRS is out of time to collect from me now because the statute of limitations has gone by. And sometimes it's my oversight, and other times I've emphasized it, but the taxpayer is just so overwhelmed that they forgot it or it fell on deaf ears. Please remember all the time to make them aware that the statute of limitations is tolled or suspended during the period that, from the period rather, that the IRS receives the hearing request. When does it resume? Well, when the IRS receives a written withdrawal of the hearing request from the taxpayer, or when the determination resulting from the CDP hearing becomes final. So that's when the clock starts ticking up again, when one of those two things happens. Now, when does the determination become final? Because it's all good, it's all nice and good to know, well, we have a black and white rule that when the determination from the CDP hearing becomes final, the limitation period resumes. But how is that, practically speaking, defined? Well, the determination becomes final when the time for seeking judicial review expires. And now we have yet another rule. When the heck does the time for seeking judicial review expire? Well, it expires 30 days after the date of the notice of determination. Or when the taxpayer exhausts his appeal rights following judicial review. So here's how this looks, just breaking it down. The taxpayer files a collection due process hearing request. The statute of limitation tolls or is suspended for the IRS during the period that this collection due process hearing request process is going on. The limitation period resumes only if the IRS receives a written withdrawal by the taxpayer of the hearing request, or when the determination from the CDP hearing becomes final. How do we know when the determination from the CDP hearing is final? We know it when one of two things happens. The time for seeking judicial review expires, or when the taxpayer exhausts his appeal rights following judicial review. So essentially, when there's a determination from a CDP hearing, the taxpayer has two options. They might be so incensed at the appeal officer's decision that they want to exercise their appeal rights, in which case they have 30 days from the date of the notice of determination for seeking judicial review, which might be in tax court or might be in another judicial forum. Or they might just sit on their hands and let that 30-day period lapse. Either one of those two things, if they let the 30 days lapse, then the determination is final, and once it's final, then the statute of limitation resumes running. However, if the taxpayer within the 30 days of receiving the notice of determination decides to seek appeal to a court, such as U.S. tax court or another judicial forum, the statute of limitations remains suspended during the appeal process, during the time that the petition is pending in tax court, say, if it's an appeal to the tax court. So as you can tell, these are very nuanced rules. They become ingrained in your mind, and they become very second nature when you're doing this work all the time. But I have to tell you that even having done this for nearly a decade now, I can't tell you how helpful I found the old-fashioned way of just putting it on a calendar or putting it in a diary and highlighting it in the diary so that I know when these deadlines are coming up. That way you don't blow a deadline and, God forbid, risk liability to your client and all the parade of horribles that can come from something that severe. And number two, it gives you peace of mind, because at the end of the day, the last thing you want to do is be looking up at the ceiling right before you're dozing off at night and be asking yourself, did I miss a deadline? God forbid. I mean, that'll keep you turning all night long. So it gives you the peace of mind of knowing that you're on top of these things and that you've got it under control. So note well that the limitations period will never expire before the 90th day after the date on which a final determination is made with respect to the hearing. So this is yet another caveat, and here's a quick and dirty example. If the statute of limitations on collection with respect to Alex's tax period listed in the CDP notice expires on August 1st, 2012, the IRS sends Alex a CDP notice on April 30th, 2012. Alex timely requests a CDP hearing, which the IRS receives on May 15th. The appeals officer sends Alex a notice of determination on June 15th. Alex timely seeks tax court review of that determination. The statute of limitations on collection would be suspended from May 15th, 2012. That is the date that Alex requested the CDP hearing, all the way until the determination resulting from the CDP hearing becomes final, plus 90 days. So that 90 days yet is another friend of the IRS. Again, it will never expire. Statute of limitations period will never expire before the 90th day after the date on which the final determination with respect to the hearing is made. How is the CDP hearing conducted? Well, now we get really into the bones of this. The hearing has to be conducted by an impartial appeals office employee with no prior involvement in the matter. And as you can tell, these are very similar to your ordinary everyday appeals officer rules. And, these come right from the playbook. The hearing must be at the appeals office closest to the taxpayer's residence. There's been changes to this. A lot of these appeals office conferences are now being held via conference call, and it's very hard to get an in-person one. So this might need a little bit of updating. So I do apologize because, like I said, the standard now has been for conference calls over in-person meetings. A hearing may be in person or by telephone. As I said, the preference now is for telephone conference calls. The taxpayer has no right to subpoena or examine witnesses. The appeals office employee must verify the validity of the assessment. This verification is just that the assessment was proper, not that the tax was due. So again, what we're really getting into is, were the procedures that the IRS used proper? Were deadlines met? Was notice given? That's really what we're talking about here in this verification process. The appeals officer isn't going to delve into was the tax actually due and get into underlying issues regarding the liability itself. Now, spousal defenses can be considered at the CDP hearing. The taxpayer does have the right to record the hearing. What matters may be considered? Well, the appeals officer has to review the IRS verification, and again, this is getting back to what we talked before. The verification consists of ensuring that the law and that the procedures have been satisfied. For example, in cases of tax assessments requiring a predicate notice of deficiency, the appeals officer must verify that the notice was properly mailed to the taxpayer at the taxpayer's last known address and that the assessment has been properly made. Second, the taxpayer may raise in any appropriate defenses, including spousal defenses, the propriety of IRS collection measures and alternatives to collection measures. The appeals officer will not consider any issue previously disposed of in a CDP hearing or in a prior administrative or judicial proceeding where the taxpayer could have contested liability and participated meaningfully. Well, this issue has been litigated and just beaten to death. This last line here that says, where the taxpayer could have contested liability. We could go on and on and on and on and on about this issue because there's one school of thought that the IRS only, that the taxpayer only could have contested liability if he or she was, was issued a notice of deficiency and given notice of what his or her rights were as far as filing a protest or filing a petition in tax court, and that if they never received a notice of determination, a notice of deficiency rather, that there's no way that the taxpayer could have contested liability. Well, the courts have gone back and forth on this issue time and time again. Third, whether the proposed collection action balances the need for efficient tax collection with the legitimate concern of the taxpayer that collection action not be more intrusive than necessary. Sadly, you rarely see the appeals officer take into consideration the latter, and it's more or less, the former, whether, balancing the need for efficient tax collection. It's not always the legitimate concerns of the taxpayer that get weighed as, as evenly as efficient tax collection does. What issues can the taxpayer raise? You see here I've written a laundry list for you. It's any relevant issue relating to the unpaid tax or the proposed levy, including appropriate spousal defenses, challenges to the appropriateness of the collection action, offers of collection alternatives, and by collection alternatives, of course, we're referring to installment agreements, things of that nature. But before the taxpayer can raise collection alternatives, he or she must have filed all required returns prior to the hearing. And again, challenges to liability only if the taxpayer has not received a notice of deficiency or had an earlier opportunity to dispute the liability before appeals. So oftentimes the latter part of that rule, an earlier opportunity, is what swallows up the rule, because in some cases a notice of deficiency is not required before the IRS resorts to collection action, and yet the courts have found that the taxpayer, notwithstanding the fact that they didn't receive a notice of deficiency, the courts have found that one wasn't required, and thus it wasn't necessary for the taxpayer to have been put on notice. The taxpayer, on the other hand, argues, well, how could I have had an earlier opportunity to dispute the liability if I didn't have notice? It goes back and forth, and you can find case law in various circuits that rule in favor of the IRS, and others that have taken the position that the taxpayer did not have the opportunity to dispute the liability. When can the taxpayer challenge the underlying liability? Again, this is very general and very broad. The taxpayer can only contest if he did not receive any statutory notice of deficiency for such liability or did not otherwise have an opportunity. So again, we're going back and kind of beating a dead horse here. The notice of deficiency, we talked about this a little earlier, it's what gives the taxpayer the right to contest the underlying liability in tax court. And so it's considered by many to be the ticket to tax court. And so the failure to have issued a notice of deficiency to the taxpayer, is usually analogous to the taxpayer not having received due process and notice of the right to challenge the tax liability. That's what the taxpayer's chief argument is. So to the extent that the taxpayer actually receives a notice of deficiency and doesn't act, by act I'm referring to filing a petition in the tax court, that's deadly. It's fatal because, in that case, the notice of deficiency, I mean, the IRS has covered all grounds by issuing it, and if the taxpayer just was lazy or, just let the 90-day period lapse without filing a petition in tax court, then they've got a major problem, because I can tell you unequivocally that in the cases when the taxpayer has received a notice of deficiency and didn't file that petition within the 90-day period, that's it. There will never be another opportunity to contest the underlying tax liability. Notwithstanding the fact that there are some circuits that are taxpayer friendly, the mere fact that that notice of deficiency was sent and to the last known address and the taxpayer did not file the petition, that's fatal. That is absolutely fatal. The taxpayer will also be considered to have had a previous opportunity to contest the liability if he waives a right to a notice of deficiency on Form 870 or Form 4549. So the issue here is, may the taxpayer contest the merits of the self-reported tax liability in a CDP hearing. There was a holding in one case that said yes, and these were the facts. So this is kind of the minority view, and I will get you a case citation for this, because even though this is a minority review, I believe it's a published opinion. But nonetheless, you should be familiar with the facts, because I'm very certain that this is going to be one of those cases where the IRS does its utmost to differentiate the facts of your case from the facts of this case, to try and distance it from the case that you're citing here, because naturally the IRS doesn't want to relitigate or litigate for the first time disputed tax liability, so they're going to do everything within their power to make this issue moot. In this case, the taxpayers were a husband and wife. They filed their federal income tax reporting a substantial tax liability, but didn't remit full payment of the liability. The IRS accepted the return as filed and assessed the voluntarily reported liability. So the key point here that I want you to really hone in on is that this was a voluntary return where the taxpayers voluntarily reported their liability. The IRS didn't audit the return or issue a notice of deficiency. After collection efforts failed, the IRS issued a notice of intent to levy, and the taxpayers responded by requesting a CDP hearing. The appeals officer issued a notice of determination allowing the levy action to proceed. The taxpayers challenged the appeals officer's determination and the amount of underlying tax liability. So here we are in a situation where the taxpayers are disputing the underlying tax liability after the appeals officer has considered the levy action and after the taxpayers had a CDP hearing. So what happened in this case? Well, this was the analysis that the court used. They reasoned that the plain language of 6330 entitles the taxpayers to an opportunity to establish that they made a mistake in their self-assessment because the IRS had not issued a notice of deficiency, which of course they weren't required to do because there was no tax deficiency. Remember that the facts in this case were based purely on the taxpayer's self-reported tax. There was no notice of deficiency whereby the IRS claimed that the taxpayers owed more than what they reported on their tax return. So as such, there was no notice of deficiency. But notwithstanding that, the court found that the taxpayers did not have an opportunity to dispute their tax liability based on the mere fact that there was no notice of deficiency issued. So you can imagine the IRS chief counsel's head just going around in circles, and steam coming from from their head over this, because they're saying, wait a second here, this was self-reported income on the part of the taxpayers. We did not determine any deficiency. We went by their very figures, and now they're arguing that the amount that they self-reported was wrong, and that they should have a second bite at the apple, so to speak, by challenging the underlying tax liability. And so it's kind of like the IRS is viewing this as, the taxpayers, having their cake and eating it too. So this holding certainly advances the policies of these sections and is consistent, in my opinion, with congressional intent that the IRS should collect the correct amount of tax. So, I'm trying to give you a very strong point of view from both sides, because for me, that's how I understand these very amorphous concepts. When you understand who would be angered and upset over the holding versus who would find it very favorable. And as you can see here, in this example, this is a favorable taxpayer's ruling, in the sense that the courts are allowing the taxpayers to dispute the underlying tax liability, notwithstanding the fact that this was a self-reported gross income, and they are basically challenging their own voluntary reporting. So what can the taxpayer do if liability issues can't be raised during the CDP hearing? The reason I included this in the slides is because time and time again, I get questions, the taxpayer comes in and they are resentful over the tax liability and they want to attack the tax liability, yet they're in a CDP hearing. Well, let's back up a little bit. You always want to try to back up and let cooler heads prevail. Option 1, determine how the liability came to be. So here's a quick and dirty example. If the examination division completed an audit and issued a dreadful statutory notice of deficiency and the taxpayer failed to petition the tax court, then tax on the notice will be assessed. And the taxpayer can follow procedures in 3598 to dispute the assessed liability. Now, more times than not, if the client will come to you at the stage of the CDP hearing, it's the period in which to file the petition has long since gone. That train has left the station. So the notice of deficiency, if issued, is usually the death knell in cases like this, and that's usually the first question you want to ask yourself. That's why it's always good to back your way into this by asking the question, how did this liability come to be? And ask the client to bring with him or her every solitary notice that they've been issued by the IRS, and if they do retain you, you still want to go after the account transcripts. Get the transcripts and see, just to verify that what you've been given by the taxpayer is accurate, because they don't know, and they can't tell sometimes the notice of deficiency from a simple, collection notice. So you always want to do your due diligence and verify the claims and the information that they've furnished you. If the taxpayer does make the request and examination does not accept the taxpayer's position, the taxpayer will have the opportunity to request the case be forwarded to appeals for consideration of the issues raised during the audit reconsideration process. Option 2 is for the taxpayer to submit an offer in compromise based on doubt as to liability. In those cases, they're usually forwarded to exams for consideration. If that compliance function doesn't agree with the taxpayer, then the taxpayer is entitled to have the offer considered by appeals. Note well that in both situations, the taxpayer has no further appeal rights beyond the administrative appeal. The penalties for abusing CDP procedures. Many taxpayers use these procedures to delay and obstruct the IRS's legitimate collection actions. I mean, this goes without saying. You don't want to be a party to that, and if you see that the taxpayer is doing this merely for reasons to delay and obstruct, certainly you want to back out. Or I found that, if you sit down and you have a conversation on a very human level with the client where, you're empathetic and you show, that you feel, and understand where they're coming from, but at the same time explain to them that, you can't be involved in obstructing or delaying, when there's no merit to the issue and when this is nothing more than a delay. And more times than not, they'll understand. If they don't, you want to be very careful, because you never want to risk your reputation, just for one client, and it's just too serious to engage in something that is this slippery. So there are some teeth here that the IRS instills to, ensure that this doesn't happen on a pervasive or widespread basis, or at all, I should say. 6673 allows the court to penalize the taxpayer up to $25,000 if it appears that the taxpayer has instituted these proceedings primarily for delay, or when the taxpayer advances frivolous positions. To discourage the taxpayers from requesting CDP hearings in the first place when they don't have legitimate concerns, there is a $5,000 penalty on any person who submits a specified frivolous submission. A request for a CDP hearing that includes a specified frivolous submission will be treated as if it were never submitted. I've never, in my experience, seen the IRS resort to penalties like this. I have, the conventional wisdom is that the tax professional is going to sit down and have the discussion that might be a little uncomfortable, but that will usually quell this from going as far as, this stage. What must appeals do after it holds a CDP or equivalent hearing? Well, they do have obligations on their end. If the taxpayer and the appeals employee reach an agreement about the case, the taxpayer will be asked to sign an agreement, not unlike any other appeal or mediation that the parties come to a resolution on. The only difference is that this is referred to as Form 12-257. At the end of the hearing, appeals issues a notice of determination, as you've heard me refer to earlier, or a decision letter. Results of the CDP hearing appear in the notice of determination. The notice of determination must describe what was considered in the hearing, confirm that all procedural requirements were met, and decide the merits of any issues raised by the taxpayer. What happens if the taxpayer doesn't obtain a favorable result in the administrative CDP hearing? Well, judicial review of decision in tax court is available from both post-lien and pre-levy administrative proceedings. Now, there are some hard and fast rules which we've talked about, and you can tell I'm belaboring some issues here, and I tend to do so when it comes to deadlines, because I really want to get them, I want to cement them in your minds and emphasize the importance of, making sure that you're doing your due diligence and, taking out your calendar or putting it in your iPhone to make sure that you have constant reminders of these review periods, because if they are missed, that's it. And not only have you hurt your client, but you've also now put yourself at risk for penalties and for actions that your client could take against you individually. And those are not pleasant. I've seen those come up, and I've actually defended tax professionals that have missed deadlines and have had civil actions levied against, or civil actions lodged against them by the taxpayer who naturally was dissatisfied and upset that those deadlines were missed, because after those deadlines have lapsed, there's no judicial review. So judicial review from an adverse appeals determination must be taken within 30 days of the appeals office notice of determination. And here's a huge distinguishing element. The notice of deficiency gives a taxpayer 90 days to petition the tax court, but a notice of determination gives a taxpayer only 30 days to file a petition requesting review of the CDP hearing. I will tell you that the notices are very good these days at stamping. Usually in the upper right-hand corner, the deadline by which the petition must be filed. However, I have seen some notices or some notice of deficiencies and notice of determinations that did not contain a stamp deadline. So just be wary of that and get on it right away. Exception is if the taxpayer only seeks tax court review of appeals denial of relief in connection with an innocent spouse claim at a CDP hearing. Then and only then would the taxpayer have 90 days from the date of the notice of determination to request tax court review. Forum issues: which court has jurisdiction over a CDP appeal? Tax court has exclusive jurisdiction over these appeals. The provision following or allowing a grace period to refile after filing in the wrong court was removed. The taxpayer may pursue a CDP appeal as a small tax case so long as the unpaid tax doesn't exceed $50,000. Can the taxpayer obtain a dismissal without prejudice? These are the facts from a case called Wagner. The taxpayers filed a CDP petition in tax court but sought to have the case dismissed without prejudice in order to pursue litigation in the federal court regarding these net operating losses that they sought to carry back to the year at issue in tax court. The tax court does not permit voluntary dismissal of a tax deficiency action. However, in this case, they allowed it. And the test is, would the IRS lose any substantial right by the dismissal? If not, then the taxpayer's motion to dismiss should be granted. In making this determination, the court must weigh the equities and do justice. And here, the court reasoned that the statutory period in which the taxpayers could refile their lawsuit in tax court had expired, so the IRS was not prejudiced in maintaining the collection action against the taxpayers as if the instant proceeding had never been commenced. Judicial review of administrative CDP determinations. The standard of review, the code itself offers no guidance on the standard of review, but legislative history does. The amount of the tax liability will be reviewed on a de novo basis, with the taxpayer bearing the usual burden of proof if two things are satisfied. First, the validity of the tax liability was properly at issue in the hearing, and second, the determination with respect to the liability is part of the appeal. If the validity of the tax liability is not properly part of the appeal, then the taxpayer may challenge the determination of the appeals officer for abuse of discretion. The propriety of the collection activity is reviewed under an abuse of discretion standard. An abuse of discretion is basically an arbitrary and capricious action without a sound basis in law, and so it's really, unless the appeals officer has made a legal or factual mistake, the decision will be left alone. And should judicial review be limited to the administrative record? This is a case that was handed down, and the issue in the case was whether when the tax court reviews a notice of determination in a CDP case, should the tax court limit its review to the administrative record, or may it consider evidence not presented during the CDP hearing. This is the rule from the Robinette case out of the 8th Circuit Court of Appeals. To the best of my knowledge, it's still good law. Judicial review of the procedural aspects of the CDP determination is limited to the record. However, and as lawyers, we always love to give gray answers, and we never make it easy with a simple black and white answer. In this case, the court said that if the record does not adequately describe the hearing process or there's a dispute over what happened during the process, the reviewing court is permitted to supplement the administrative record with other evidence outside the record. So again, the caveat here is if the record does not adequately describe the hearing process or there's a dispute over what happened during the process, then outside evidence is admissible. So I suppose that strategically the defense attorney or the attorney for the taxpayer might want to argue that there's a dispute over what happened during the process and see where that gets them in terms of getting additional evidence admitted outside the record. But for all intents and purposes, judicial review of the procedural aspects is limited to the four corners of that administrative record. These are some facts from the case. I'm not going to get into all the details. And again, we've covered this. Tax court jurisdiction over CDP appeal is premised on a notice of determination. That is the taxpayer's ticket to get into tax court on appealing a CDP appeal from the appeals office. Equivalent hearings, we've talked about these. They are if the taxpayer's appeal is not timely filed, meaning it's filed outside the 30-day period, the IRS may still grant an equivalent hearing, but there are no appeal rights. The appeals office will provide the functional equivalent of the CDP hearing. Again, no judicial review. The IRS is not prohibited by statute from further levies during the time the appeal is pending, and the statute of limitation is not suspended. So there are some negative consequences attached to the functional equivalent of these hearings. This was an issue, and I'm not going to get into the details of this case, but in this case, the issue to be decided was, must the tax court look behind the notice of determination to see whether a proper hearing was offered in order to have jurisdiction to review the determination? No, they don't have to do that. The quick and dirty rule here is just like with a notice of deficiency, in determining jurisdiction, the tax court will not look behind the notice of determination to determine whether it was validly issued. It will examine only the notice of deficiency itself to determine whether it's valid for jurisdictional purposes. Now, the tax court has upheld CDP determinations issued without a face-to-face CDP hearing. However, if the taxpayer does ask for a face-to-face hearing, appeals must give it to him or her at the closest appeals office to the taxpayer's residence. There's been a lot of changes on these in-person meetings, so do check the IRS website, because I'm not so sure that this is still the status of the law right now. As I said, it's been the IRS and appeals have migrated more to a telephonic conference in lieu of these in-person meetings. Okay. We've discussed appealing tax courts. Well, actually, we haven't discussed appealing tax court's decision. The issue here is what circuit would you appeal? Would you appeal an adverse ruling from a tax court decision in a CDP case? It doesn't say so, and so the default venue is the Court of Appeals for the District of Columbia. But note, the IRS will not object to venue when the taxpayer appeals a CDP decision to the Circuit Court of Appeals of his residence or principal place of business.
Do you have any questions?
Oops, I'm sorry. So that ends the presentation. What happens sometimes is when I advance to a slide where there is embedded already an embedded link to a recorded presentation, it automatically plays. So I apologize for that. I will see if I can still pull up that last slide without bothering you with the voiceover. This is my contact information. Please don't hesitate to reach out for me at any time if you have any questions. And it was my pleasure presenting this to you. I will upload this to my blog on my website right away so that you can take full advantage of reviewing it. And I look forward to seeing you in next week's webinar, same time, same day, Wednesday at 11.